Hello friends, welcome to my channel. This is Mayank Shah, practicing company secretary based on Ahmedabad and majorly dealings with the corporate litigation matters. So here, this video is in a continuation of earlier videos with regards to the jurisdiction of tribunal under the Companies Act, in which my earlier videos we have gone through section 7, section 48 to section 55 with regards to the redemption of preference shares, section 58 and section 59. Rectification in the register of members and register of securities. So let's go ahead without wasting of time. The another section where the jurisdiction of tribunal vested is section 61. Section 61, as we are aware about, section 61 is all about alteration of authorized share capital by way of increase in authorized share capital, consolidation, division, cancellation. So where it has been prescribed that by passing in resolution, that is ordinary resolution, the company can alter by altering the memorandum of association can alter the authorized share capital, in which section 61 1b which prescribes that the company may consolidate and divide any or all the parts of the shares into the larger amount than its existing shares, provided that, but if that consolidation and division alter the voting percentage of the shareholders, then company needs to require to take the approval of tribunal. Then and then it can consolidate and divide its share capital. So if company wants to consolidate and divide, that means if company having the shares which having the face value of 10 rupees, and after consolidate and divide the shares into the 100 rupees face value, then this is called as a consolidation division of the shares into larger amount than it's existing. Now, what the manner of application? If there is a change in the percentage of voting rights, because if the shares are 100 having the face value of 100 and after consolidate divide, if the face value of the shares becomes 500, then in such a cases some of the shareholders which holding the shares, and that if calculating according to the ratio then comes out in fraction, then in such a cases they might be not given shares, and as a result with another shareholders of another voting rights that may increase or decrease, and that's here is the changes in the percentage voting percentage. So that's why company is required to take the approval of tribunal if there is a change in the voting percentage. Now, what is the manner of application? The manner of application, that is Rule 71. It has been Rule 71 of NCLT Rules 2016, which prescribe that application, the format of application is NCLT 1, and here the annexure that are supposed to be made is the particular registration document MOA, where there is a power for consolidation and division has been given, clause is given. Second, particulars of capital structure before consolidation division and after consolidation and division. Third, what terms on which the consolidation division made, the minutes of meetings, those shareholders who have considered, the shareholders who have opposed, and for the opposed what terms, and if the shares are fraction creating, if the shares are comes out fraction, then what will be the solution that company has find out. So this all need to require to be mentioned in the format of application NCLT 1, and that are supposed to be, and the mandatory supposed draft that are affidavit verifying application, memorandum of appearance, synopsis, notice of admission, that are draft which are supposed to be annexed with the application. Now the tribunal at the first hearing gave the direction that to serve the notice to the whatever the respondents there are, ROC, RD, whatever the departments are also, and if an objection, company has received the objection in said regards, company is required to submit the same to the RD, ROC. Now, so after hearing the parties, the tribunal either confirm or dismiss the application. Barabar. Now, what will be the case law? The case law, in one of the case law, it happens that the company has consolidate and divide the shares of rupees 10 into having the shares having the face value of rupees 10 to 6,000 rupees, and that is why some of the shareholders have opposed, and that's why the company, while the company move before the NCLT for confirmation, then in such a case the company after the first hearing, the company has intimated the ROC, company has given the intimation of ROC about next hearing, and in terms of that ROC has received the objection. So in next hearing, while arguing the case, the ROC has put a contention about the objection received from the shareholders, stating that the said consolidation division should be cancelled. And also ROC's objection raised with regards to the protection of minority interest of minority shareholders, because the minority shareholders which are holding the shares of minimum amount, so what will be them? Because may there are the shareholders who holds less than 6,000 then shares then, and that's why the tribunal NCLT Bangalore bench has dismissed the application. Agreed with the decision, the company moved before the NCLT, and in NCLT, the NCLT has overviewed the petition, and in which the company has contended that whatever the ROC which has raised the objection with regards to the they have received the objection from the shareholders, that is 7 shareholders. The ROC has received the objection from 7 shareholders, out of which the 4 has transferred its shares to the promoters. Only 3 is left, and that the company is ready to purchase shares of those. And along with, the company has duly complied with the procedure which has been prescribed to the Companies Act and have passed the resolution, and the shareholders were agreed that of 92% of the paid up share capital holding. And NCLT also has the question, what about the protection of interest of minority shareholders? And in terms of that, in response to that, the company has contended that the company has created trust by passing the board resolution with regards to the shares which are arising out of the consolidation division with infraction. Those shares are transferred, fractional shares are transferred to the trust, then trust sold that preference shares, and which is more than the value of face value and market value, and whatever the proceeds that has been realized, that will be distributed between the shareholders who are entitled for a fractional shares. So this is the provision that has been made for the minority shareholders who are entitled for fractional shares. By considering the same, the NCLT has observed that there is no ground to cancel and dismiss the application, hence the application has been considered and has approved the same. So this is the all case. In short, whenever the company is making consolidation and division, should remember that it should be in compliance with the law, and second, whatever the shareholders which are opposed should be paid off or should make the provision for protection of them who are entitled for fractional shares, like creation of trust. So this is the case of section 61(1)(b). Now move forward for another section, that is section number 62. As you are aware about, section 62 is all about the issue of further shares. Whenever the company wants to issue the further shares, that should be in a compliance with the section 62(1)(a) or (b) or (c). Now here 62(4). 62(4) states that notwithstanding contained in a subsection 3, that means what subsection 3 states? Subsection 3 states that whenever the company has issued the debentures, loan, in which the terms is provided for conversion, then in such a case company need not to be required to follow the 62(1)(a) or (b) or (c). In 62(4), it has been stated that nothing notwithstanding contained subsection 3, whenever the debentures are issued or loans are taken from the government, debentures are issued to government, loan taken from the government by the company, then in such a case, if government is consider it necessary in the public interest and government is if deemed fit, then government may pass an order or may give an order and direct the company to convert the debenture or loan or any part of it into the shares on such a terms and condition as deemed fit to the government by prescribing in the order, and direct the company to alter the same and to issue the same and to issue the further shares according with the order. If company agreed with the decision, agreed with the order of the central government, because if company wants not suitable to that terms in which the government has passed an order, then in such a case company may move before the NCLT for cancellation of that order, and the time limit is 60 days. The company may move application within 60 days, and here the rule manner of application and rule in which the application can be made, and that is Rule 72 of the NCLT Rules 2016. And the manner of application here, the manner of application is different, that is NCLT 9, not NCLT 1. NCLT 9 and the annexure that are supposed to be made, that is particular of capital structure, the 3 years of balance sheet, the terms on which the loan has been given, loan has been taken from the government or debenture loan, terms on which the debenture are issued, that the record of the debentures of interest paid by the company, so that it can be said that company is viable. Then why the company is viable, then why the company needs to require to convert the debentures into the equity, the terms on which the government proposed to issue the shares, along with that terms may make an application in NCL along with the NCLT and on the other supporting draft which are required to be made, that we have already gone through. So after consideration of after giving opportunity to the government and parties, NCLT may either admit the application and cancel the order, or dismiss the application and direct the company to comply with the same. So here there is no case law. That is because the debentures subscribed by the government or loan given by the government to company, such companies are Samruddha company. So rare of the rare case it happen, else it will not happen. So let's go for another section. Another section is section 66. Section 66, it's all about reduction of share capital. Company may reduce its share capital by any of the following ways, but for which the company is to require to take the approval of equity shareholders by passing the special resolution. The company also needs to require to take the approval of tribunal, because here by reducing the share capital, the company is reducing the liability of members, liability of owners, and for which and that's why while taking the confirmation from tribunal, the tribunal is oversee that whether the interest of third party, that is creditors, is secure, is discharged or not, and that's why the confirmation of tribunal is required. Now, here the special resolution is also required because there is an alteration of memorandum in authorized share capital. Its alteration is that because of that the approval of shareholders by way of special resolution is required. Now, the manner of application, it prescribed not for which the separate rule is that is NCLT procedure for reduction of share capital of the company rules 2016, and the manner of application is RSC 1. Along with that, the annexure that are supposed to be made is the list of creditors, which should not be earlier than 15 days from the date of application, which should be certified by the managing director or by 2 directors. Second, certificate from auditor by stating that the list of creditors which is attached to the application is correct. Third, certificate from auditor stating that the accounting treatment which has been made by the company with regards to the reduction of share capital is as per the accounting standard which has been prescribed under section 133 of the Companies Act 2013. Along with that, certificate from auditor and declaration of director stating that as on the date of application, the company is not in areas of repayment of deposit or part thereof. Because as on the date of application, if the company is in areas of the deposit or part thereof, then company is ineligible to make an application. Now, along with that, supporting annexure that are supposed to be made, notice of admission, affidavit, verifying petition, memorandum of appearance. That's it. Within 15 days from the application to tribunal, the tribunal at the first hearing give the direction to the applicant to serve the notice to the secretarial department, that is ROCRD, and SEBI in case of listed company in a format of RSC 2, to give the individual notice to creditors in a format of RSC 3, and to give the public notice in a format of RSC 4 in a vernacular newspaper and English newspaper within 7 days from the direction. Also, if the company along with the application attach the consent of all the creditors by way of affidavit, then tribunal may waive the company from the requirement of service of notice to the creditors and publication. So within 7 days from the direction, company is to require to follow the compliances, and within 7 days from the service of notice and publication of notice, company is to require to file an affidavit in a format of RSC 5 stating that whatever the compliance direction which has been given by the tribunal, that has been complied with. And for objection, the time limit is given is 3 months. Within 3 months, creditor, stakeholder may raise objection before the tribunal by serving the advance copy to the company. So within 7 days from the expiry of 3 months, the company file an affidavit stating that the company has not received any objection or received objections that are attached with the affidavit. Now, so at the second hearing, the tribunal gave the opportunity to the respondent or to the person who has raised the objection and to the company to answer that objection. So at the second hearing, the tribunal should confirm that the interest of every creditors which are stated in the list of creditors that are supposed to be discharged or protected, then and then give the confirmation. Whatever the order, the confirming the reduction, that should be in a format of RSC 6, and within 30 days from the receipt of order, the company is required to file the same with the ROC in a form INC 28. And ROC, after fulfilling that the company has complied with the followed the procedure and complied with the direction, then issue and certificate which is in a format of RSC 7. So this is all the procedure of reduction of share capital. Now this is important. After reduction, any member is not liable to pay on the paid up share capital which is more than the difference between the amount paid up on the shares before reduction or reduced and the by order of tribunal the amount is reduced, not more than that for which any member is liable. It's also important now, after reduction, if any creditor who is not aware about the procedure, or because of his nature of debt, he is not included in the list of creditors, then and the company along with the condition is and the company is made in default in terms of section 6 of the IBC in which paying the debt towards that creditors, then every member at the time of when the order is registered with the ROC is liable as if the company is in a winding up on a second day. So this is the case. So here the creditor who is entitled to raise an objection are those who are liable, who are eligible to raise and to make an application under IBC that prescribed under section 6 criteria, and that is whenever the corporate debtor has committed a default of an amount of rupees 1 lakh, that limit has been exceeded, that is 1 crore. So that creditors, if that creditors, then in such a case they can raise an objection they are eligible to raise objection, and if the company is not include such a creditors in the list and made in default under section in terms of section 6, then every member who are at the time of member and are liable as if the company has commenced winding up on an immediate next date. Now, if that is important, if the director of the company or company is knowingly not include any of the creditor name in the list of creditors or suppressing any of the creditor or abets to conceal any of the name of creditor or nature or amount of that debt, then each of that director is liable under section 447. The case law is, in one of the case, the company has excess of capital, and that's why company wants to cancel its paid up share capital, some of part of paid up share capital, and against which the one of the company which are holding some part of the paid up share capital of the company and also agree with the cancellation and surrender the same. Here the surrender is a consequence of cancellation, otherwise surrender is not allowed under the Companies Act. So except as a terms of part of the loan given and conversion option is there at the time of issue. So here at the time of conversion, the tribunal is going through the case and the company is sound. Company has taken the consent of creditors. Company has followed the procedure, and that's why the company has complied with all the directions, and that's why the company and no objection has been received from any of them, either shareholders, stakeholder or creditors. And that's why the tribunal has confirmed the reduction. So this is the whole case where the jurisdiction of tribunal lies. There is reduction of share capital. The company is required to follow the procedure, take the consent of creditors, and requisite approval from shareholders, so that the objection from the creditors or shareholders chances are very less, and that's the chances is more to confirm by the tribunal, the reduction of share capital. This is all the case of section 60 is where the jurisdiction of tribunal is vested. Another sections where the jurisdiction of tribunal vested are section 71(9), section 71(10), section 73(4), section 74(2), section 76(2). All these 5 sections we are taking simultaneously because the manner of application that are similar for all of these sections. So let's go one by one. The first is section 71(9). As we all are aware about, the section 71 is all about the issue of debentures, and section 71(9), wherever the company has issued debentures, secure debentures, the said debentures are secured by debenture trust date, and debenture trustee is appointed. Wherever the debenture trustee comes to the conclusion that the assets of the company becomes or likely to become insufficient in order to redeem the debentures which are due for the redemption, or pay interest thereon, and in such a cases debenture trustee may make an application before the tribunal, and the tribunal may by passing an order direct the company not to incur the further liabilities, restrict the company not to incur the further liabilities. That is section 71. Section 71(10), wherever the company incurs the default in repaying the debentures, in redemption of the debentures, and interest due on it, then in such a cases any of the debenture holders or all of the debenture holders or debenture trustee make an application before the tribunal, and tribunal pass an order and direct the company to immediately redeem the debentures and pay the interest on it. So this is all about section 71(9)(10) and section 71(9) and section 71(10), that is for pertains to the debenture. 73(4), notwithstanding containing in a 73(3) subsection 3. 73, it's all about the acceptance of deposit from shareholders. Then in such a cases, section 73 subsection 3 states that wherever the company accepted the deposit, the company should redeem on the terms on which it has been accepted. So notwithstanding as prescribed in section 73(3), when the company is not repaying the deposit on terms on which it has been accepted, where the company has fails to repay the deposit or part thereof or interest thereon, then in such a case the depositor concerned or all of the depositor or deposit trustee may make an application to tribunal, and the tribunal may pass an order and direct the company to immediately repay the deposit or part thereof or interest thereon. So this is 73(4). 74, it's all about the repayment of deposit which are accepted by the company before the commencement of this Companies Act 2013. Then in such a case, 74(2), in which 74 it has been prescribed that within a period of 3 years the company is required to repay the deposit which are accepted before the commencement, in which if the company is not in a position to repay the deposit or any part of it or interest due thereon, then in such a case company may make an application before the tribunal and request for the extension in a time for the repayment of deposit or part thereof or interest due on it. And in such a case, tribunal, after considering the financial condition of the company, then may extend the time and may allow the company to repay the same in a further in a time that has been granted by the tribunal. So that is 74(2). 76, it's 76(2). Section 76, it's all about when eligible company accepted the deposit from public. The eligible company, while accepting the eligible company, as we all are aware about that, eligible company means a public company which having the net worth of rupees 100 crore or turnover rupees 500 crore, and they can accept deposit from public. So in section 76(2), it prescribes that the provision of this chapter that mutatis mutandis applied to this type of procedure. So whenever the company accepted deposit from public and made in default, then in such a cases, as prescribed in 73(4), the depositor may make an application, and here the public depositors may make an application before the tribunal in such a circumstances, and the provision of the said mutatis mutandis apply. So these all are sections 71(9), 71(10), 73(4), 74(2), and 76(2). Now the manner of application, which has been prescribed under the NCLT Rules 2016, that here it is prescribed in 2 ways. The first way is when the application is required to be made under 71(10) and 73(4), where the company has failed to repay failed to redeem the debentures or interest thereon and fails to repay the deposits and interest due thereon or part of it. Then in such a cases, the application format is NCLT 11. Here the format is different, NCLT 11. And who can make an application? So depositor or all of the depositor or the deposit trustee, debentures or all of the debenture holder or debenture trustee. Make an application before the tribunal. Then what annexures that are supposed to be made. So NCLT 11, along with that, you need to require to prescribe that the details of deposit receipt number, debenture certificate number, distinctive number, the details of that debenture holders and the deposit holders, then the terms on which the deposit are accepted, the terms on which debenture issued, when it is due for the interest, when it is due for the redemption, when it is due for the repayment, then when the company is made default, in what, in payment of repayment of deposit or interest, repayment of debenture or interest, when it is due, up to what extent the company has paid the amount, financial condition for that 3 years financial statement annexed with this application. So that are supposed annexures that are required to be made when the application is required to be made under section 73(4) and section 71(10). Now, when the company, when the application is required to be made 74(2) and 76(2), right, with 74(2). That means when the company is required to make an application for to take the extension in time, then in such a case the application format is NCLT 1. Along with that, the particulars of particular registration document, financial audited last 3 years audited financial statement from which it proved that the company is facing the financial trouble. Also, after the first hearing, the company is required to serve the notice of next hearing date to the ROC&RT. Company is required to take the report from ROC&RT, and on the basis of report, the tribunal give the order. Within 60 days, in both the cases, tribunal pass an appropriate order, either admit the petition and direct the company to repay the deposit, repay the debenture and interest or part thereon, or dismiss the application. So this is all about the case where section 71(9), section 71(10), section 73(2), 73(4), 74(2) and 76(2), where the jurisdiction of tribunal vested. Now, for the case laws, so here two cases are involved: debenture and deposits. So first of all, debenture. For debenture, in one of the case, it happens that the company has issued the debentures and has made default in prepayment of debentures and interest and on in interest. Then in such a case, the debenture holders have issued the notice to the company and to the debenture trustee. But the debenture holders have failed to receive the response either of the side, that is from company or debenture trustee, and as a result of it, the debenture holders have made an application before the NCLT Bangalore bench and contending that the company has failed to redeem the debentures, against which the company has contended that the company is facing the financial trouble and the said issue is pending before the arbitration. And that's why, considering the financial condition and proceeding pending before the arbitration, then considering the same, the tribunal has granted relief of 6 months. Agreed with the decision of NCLT Bangalore bench, the debenture holders move before the NCLT on the ground that company has failed to prove and company has failed to submit that the arbitration proceeding is going on. There is no evidence on record. Second, the company has also failed to prove that the company is facing the financial trouble. Company has not submitted the previous year financial statements. And considering the same and considering no record of the proof that the arbitration proceeding is pending, the NCLT has admitted the application and direct the company to immediately redeem the debentures and interest due thereon. So this is the case of debenture. Now, deposit. One of the companies accept the deposit before the company under the Companies Act 1956 and under the Companies Act 2013. The company is in the field of jewellery. Because of the sudden increase in the excise duty on the jewellery, the company is facing the financial trouble, as a result of which the company has decided one plan for the repayment of deposit accepted by the company and interest due thereon, and that plan moved before the NCLT Delhi bench and request NCLT Delhi bench to grant the further time in order to repay the deposit and in order to pay the interest due thereon as per the terms on which it has been accepted. Considering the same, the NCLT Delhi bench has granted the time of 3 months. During that interregnum, the companies also failed to repay the deposit which are due for the redemption and interest due thereon. Then in such a cases, the company has considered had conducted the board meeting and has prepared the plan for the further extension and moved before the NCLT New Delhi bench. In this interregnum, the depositors to whom the company has made default also move before the NCLT New Delhi bench under section 73(4) and make an application. considering the same, NUDLE is considering the application 73.4 and 74.2 and also taken into consideration the again already the time has been granted of 3 months and again the company is come, and that's why the NCLT bench has directed to the company to repay the immediately deposit whatever which are due for the redemption, repayment and interest due thereon. So this is the whole case of deposit and debenture. In short, the tribunal, while considering the case, take into consideration the financial conditions, whether this financial concern is utmost that the company is not in a position to repay, and in that case where it has been clearly prescribed in section 70 and 10 the tribunal should give immediate order to immediate redemption for the immediate redemption and immediate repayment. One of the important things I would like to share is that here the debenture holders and depositor holders may also make an application as a financial creditor under section 7 of IBC. Yes, debenture holders and deposit trustee deposit holders both are termed as in financial creditors, and their debt from the company are also termed as in financial debt, which is fit under section 5 of the IBC. So they can make an application under section 7 of IBC as a financial creditor, and they can move for this initiation of CRP against the said company, against the said corporator, where the corporator also cannot take the cause that they are facing the severe financial condition. If they are taking that argument point, the company, the tribunal may pass an order for the initiation of CRP. Again, I would like to share that if there is a misuse of the funds and the company is taking for granted, then in such a case, deposit holders and debenture holders can also make an application under section 245 as a class action suit. They are also eligible to make an application under section 245 if there is a mismanagement occurred, if there is an oppressive act has been committed by the company against them. They can also move. So learning point is there, not only under the Companies Act under 70, not under 71.10 and 73.4, the deposit and debenture holder can make an application, but also can make an application under the IBC if they fall under that criteria. So that's it for the day, but the subject is remain pending. The another part is there. So till that, thanks for watching, and if you like this video, then don't forget to like and subscribe my channel. Till that time, stay home, stay connected and stay safe. Goodbye.